tuned in to The Andrew Lawton Show.
Welcome back. Well, obviously, some of the people who wanted to go to Ottawa for the big rally have not been able to if they had to fly to get there. Not everyone has a big rig or can take the time to drive across the country. And that's because there still is, in effect right now, a vaccine mandate for air travel. No end in sight to this. No willingness from Justin Trudeau to ease up on this, even as we've moved to the Omicron era, in which whether you're vaccinated or unvaccinated doesn't seem to have too much of an effect in whether you're going to catch or spread Omicron. So what's happening now is people are fed up with this air travel vaccine mandate that, like anything else, is looking like it's going to be this indefinite measure that we never really get rid of, much like the vaccine passport, much like a lot of the other restrictions. There's a big challenge that was launched this week in federal court by Brian Peckford and other applicants as well, but Brian Peckford is notable because he is the former premier of Newfoundland. He's also the last surviving of the crafters of the Charter of Rights and Freedoms, of the Constitution Act of 1982. He's the last living of those premiers that were negotiating and adopting in the 1980s and ultimately in 1982, the document that now forms the backbone of Canadian rights and freedoms. Or is supposed to anyway. We'll get to that in a little bit. But why this is important is because Brian Peckford is filing a charter challenge. He's saying that the government is ignoring the charter that is the linchpin in his legacy as a premier. I'll let him explain exactly why that is. Brian Peckford joins me now, the Honourable Brian Peckford. It's good to speak to you, sir. Thanks very much for your time today.
Yeah, thank you for having me.
Now, we talked last time. It's nearly 40 years since the Canadian Charter of Rights and Freedoms was adopted, since the Constitution was brought home, as they say, and you're now taking the government to court for violating the very charter in which you were instrumental in passing. Why?
Yeah, I think this is rather historic. I don't know of any other First Minister in the history of Canada who's taken the federal government to court over something that First Minister had a hand in creating and writing. And why I'm doing it, Andrew, is because over the series of months since I talked to you and before even that, I've been watching, as many Canadians have, with great alarm, as the governments have moved more and more in the field of restricting individual rights and freedoms. And of course, the Charter of Rights and Freedoms is very dear to my heart, being one of those who was involved in creating it. And I've issued many statements. I've done very many interviews, 50 or 60 interviews across the country. And I've done a lot of public meetings and so on. And I've heard from an awful lot of people. And a lot of them agree with me that if we don't win and the Constitution and the Charter is honored this time round, this will establish a precedent which will dilute the power of the Charter next time round. And therefore, it's going to be this erosion of our individual rights and freedoms. And I guess a lot of people would say the violation of our individual rights is not justified, even under Section 1 of the Charter. My argument, of course, is that Section 1 doesn't even apply, because I remember well that Section 1 was supposed to apply when the state was in peril. The state is not in peril. And we had alternatives, as Lieutenant Colonel Redmond has pointed out, as early treatment the doctors have pointed out, right? We've had alternatives to doing this, the Great Barrington Declaration. So it's not like we didn't have alternatives. So my point is, my individual right as a Canadian to travel freely in this country has been severely curtailed without justification, and it's necessary for me as one Canadian and as one person who's been involved in the Charter of Rights and Freedoms to stand up for the individual Canadian.
Before we get to the bigger picture and also to Section 1, which I'm glad you've raised there, let's talk about what your complaint is, because specifically you're taking issue with the vaccine mandate that Justin Trudeau put in place in October that says you cannot board a plane at any commercial airport in Canada unless you are fully vaccinated, which also means you can't fly from Vancouver to Halifax, say, but more importantly, it means you can't fly from Toronto to England or Toronto to somewhere else else in the world that perhaps doesn't have a vaccine mandate, which effectively landlocks Canadians, especially now that the United States has put in a vaccine mandate for its land border here. So your complaint, I'm assuming, is that the mobility rights, that every Canadian has the right to enter, remain in, or leave Canada, are being just completely obliterated by this mandate, correct?
No question. It's Section 6 of the Charter, in which it says every Canadian has the right to travel anywhere in Canada or leave Canada. That's a fundamental right that every Canadian has as a result of the Charter. And so there's no question. Listen, Canada is a nation of motion, from the MacKenzie River to the St. Lawrence River, to our explorers, to our later bush pilots, to the CN and CP moving across the nation. These movements were all part of creating Canada as we know it today. Without that rail line coming west, who knows what kind of a country we would have today. And so movement and travel are integral to who we are as Canadians and in creating the country. And that history is very important. That was solidified in the Charter of Rights and Freedoms. And so therefore, it's extremely important. And as you say, it also to leave Canada as well. That's part of that mobility right. And so it has severely restricted. I have law firms calling me from all over Canada about, and industry, by the way, industry lawyers who are saying they want to go to court and they want to challenge the federal government as it relates to this business of the mobility, because it's now hurting our industry. It's hurting industries in Canada in their ability to do business. So it's extremely important. And there's been no cost-benefit analysis done to show that, that getting aboard a plane is any more dangerous than going to Walmart, So this whole business of this restriction has been done without justification, even if Section 1 of the Constitution applied.
One of the interesting things about it is that no one, even at the height of the pandemic when the border was closed, no Canadian could be denied entry to their own country. This is the fundamental right of citizenship. The government could make it difficult for you, like demanding pre-arrival tests and quarantine, but no Canadian could be prevented from entering. And when they put the flight vaccine mandate in place, one thing I noted was that they didn't put the mandate in place for getting on a plane to Canada. So in a way, the government was acknowledging that this charter right exists, acknowledging that you can't prevent Canadians from entering their country, but they're not as concerned with it on the other side of it, traveling within the country or exiting the country.
Well, I think both those points are extremely important. And perhaps the most important of those two is traveling within your own country. I mean, your family, business, and so on, from one province to another, making it more difficult. For example, the truckers' convoy right now, they wanted me to come to Ottawa to speak. Well, how am I going to get to Ottawa to speak?
You'd have to rent a big rig.
Yeah, and so it would be very, very difficult for me to be able to do that, given my other business activities right now, my other personal activities in having interviews like this. I'm busy all day long. From 8 to 11, I'm doing interviews and doing public meetings and the like, and doing speeches online. So it completely inhibits my ability as a Canadian, and I know there's hundreds and thousands like me. And then, of course, exactly the discriminatory nature of it. In yes, out no. I mean, that does not make sense, and it's not consistent with any kind of law or reason that one can think about. But I woke up this morning thinking about our history, and that was the phrase sort of that I came up with, a nation in motion. We have been, ever since First Peoples, right? A nation in motion. They lived off the rivers. They lived off the coastline. They lived in moving in canoes and other sea craft, right? We're a nation in motion. The MacKenzie River, is an operating river every day, right? The Yukon River, right? The St. Lawrence.
Confederation itself, Brian, you've relocated to British Columbia. BC only joined Confederation because of the promise by John A. Macdonald of that transcontinental railway. That was the only reason they joined the country. So because there was an importance of moving people and goods from one side to the other. And now you couldn't board that train. John A. Macdonald could not board that intercontinental train to go to BC if he weren't vaccinated.
Absolutely. And this is a complete abdication of government's responsibility in our view. That's the argument we'll be making before the court. Of course, we have to argue that before the court and persuade them to sustain our right of travel over the other concerns that the government may have, which have not been completely articulated. And I think this is where our argument has a lot of merit, is because on the other side, on the travel ban, when it was instituted, there was no argument made as to why they were bringing it in, except that they had to bring it in because it was going to affect the transmission of the virus. At the same time as they were knowingly been informed, they've just been informed in the last few months that vaccinated people receive the virus and transmit the virus just the same as unvaccinated people do. So their whole health argument seems to be crumbling, and therefore to continue to insist upon this kind of restriction on our freedoms does not seem to us to be justified.
Let me ask you then about the internal mobility here, Brian, because one of the responses that people would give is, well, there's nothing stopping you from driving. Your right to go from BC to Ontario hasn't been harmed because you could get in a car and go. It might take more time, but your ability to do it still exists. And what is the response to that?
There's a number of responses to that, not the least of which is that the whole concept of progression, of becoming modern. So you want to select what is no longer modern in our society and constrict that by some medical condition, right? It sort of flies in the face of our natural thought of moving ahead as a country and progressing as a country, right? I find that very offensive. The other thing is, of course, it makes it more difficult. They're constricting the manner in which I can travel. Right, and the whole idea of the mobility right is your right to travel in Canada, full stop. It doesn't say by car, by plane, by train, or by boat, right? It is a general right of every Canadian. And so by restricting which way I can travel, that interferes with that freedom.
Yeah, and I guess the extension to that, even leaving the country, there's nothing legally stopping you from, getting a canoe and taking the MacKenzie River all the way to the Pacific and then perhaps canoeing your way to Tuvalu or something. But in reality, the practical means of travel is something that takes place by air. And when the government takes that off the table, they do effectively tell Canadians they aren't allowed to travel, to say nothing of people that live on islands. Newfoundland, for example, where some ferries have put vaccine mandates in place, depending on where in the country they are. So there are significant restrictions here that, for all that Canadian leaders love to vaunt the vastness of Canada, they're now saying that only some Canadians can enjoy that vastness.
Absolutely, no question about it. And I find that, an argument that cannot be sustained, as you say, when a government deliberately goes about the business of restricting your right as a Canadian, we know there's something, fundamentally wrong. And this is what's happening right now. I think of the bush pilots. Why did we get into air travel at all then, in that case? If you're going to start discriminating against some Canadians and how they can travel based on their medical condition, you can still go this way, you can still go that way. Well, that defies the whole nature and progression of our nation. And to begin to enter into a world of discrimination, it seems to me, is a very, very slippery slope that we should never go down or even enter unless it is unbelievably justified in a very extreme circumstance. And this is not extreme circumstance.
On a lighter note, I have to correct myself. If you take the MacKenzie River, it's not going to get you anywhere near the Pacific. So I don't recommend following my directions if you are trying to canoe your way to Tuvalu. But on a more serious point, yeah, you have to go around Alaska. But I don't recommend it this time of year. But let me ask you, Brian. Go ahead.
You can go up from Hay River and go all the way to the Uktuk.
There you go.
Take a boat. But
there you go. Then you can just go across to Siberia. It might be quicker. But
you can't do it. And it will take you weeks and weeks to do it.
Let me ask you on a more serious point here about the way that governments are viewing this, because Section 1, which you mentioned earlier, this is, I'd say, one of the more dangerous sections we've seen in the last 40 years of the Charter, because it's the section that says all of the rights you're about to read are subject to reasonable limits. And the court has, of course, developed a test for that, I know you're going to finish the line, and I want you to do that, but I'm talking about how it's been perceived, because governments have used this as sort of a trump card that they can just say, well, this other thing's more important. And you are right, and I knew where you were going with this. So tell me, why does that not capture the entirety of those Section 1 powers?
Well, number one, Section 1 doesn't apply in my view. As one of the writers of Section 1, it was meant to be in when the country's in a state of peril, insurrection, or war. This is not a state of peril, insurrection, or war. So my number one argument is it doesn't apply, and therefore the unconstitutionality exists. Number two, my argument is, even if you wanted to apply for argument's sake, and that's what you want me to do, engage in an argument on Section 1, you just mentioned, and this is one of the things people perceive it, because it talks about reasonable limits. There are 4 tests. The first one is demonstrably justify what you're doing within reasonable limits by law, all in the context of a free and democratic society. You tell me that the government of Canada or any of the governments of Canada have met any or all of those 4 tests. In the case of the travel ban, they have not demonstrably justified that it's necessary. Where is the report? Where is the cost-benefit analysis? And and then free and democratic society means a parliamentary society. That's what Canada stands for, parliamentary democracy. Where are the parliamentary committees? We have 14 parliaments in this country, and none of them have been engaged in any meaningful way in discussing and debating these mandates. And therefore, 2 major conditions of Section 1 have not been met. And therefore, what is happening is unconstitutional. So I think on both counts, 1, it doesn't apply, but if for argument's sake it does, on both counts, the government, in my view, is acting unconstitutional, and that's what we'll be arguing before the federal court.
I take what you're saying about the intent of Section 1, and you're the last surviving of the architects and first ministers, so I think your words on this should carry a lot of weight, and I think do, certainly in my estimation. But we look at the jurisprudence on this, and courts have at times, especially in the last 2 years, taken very broad interpretations of those limits. And we've seen, not that they've gone to the Supreme Court, but at lower courts, we've seen government side, or courts side with government on this. Looking back on this, is that a section that you would, if you were to go back to 1982 with the knowledge you have now, is this a section that you would support in the way it's worded? And I guess what I mean by that is, do you feel that Section 1 itself was a mistake in the way it was crafted, or do you just feel that governments and courts have wronged?
No, not at all. Absolutely. It wouldn't change a word. I wouldn't change it. I'll tell you why. Section 1 was not negotiated in as Section 1. Section 1 was negotiated in the context of all the other sections of the Charter. And the Charter was negotiated in the context of all the other sections of the Constitution Act 1982. That's what everybody forgets. That was the deal. If we go back and try to reopen that, other provisions of the Constitution will get changed. There will be more negotiations, more to and fro, right? That's the danger that you face when you start to reopen things, because you're not reopening just Section 1. You're reopening the Charter. You're not just reopening the Charter, you're reopening the Constitution of 1982 and the Aboriginal rights of 35, the equalization rights, right, that are in there, the natural resource rights that are in there, the minority language rights that are. This was a negotiation on all these matters, okay? So all these would come back in play, and Quebec would be there with other demands. So what we have in any reasonable person's mind, right, to me, especially with if those 4 conditions weren't in there, we didn't say demonstrably justify, if we didn't say by law, if we didn't say in reasonable limits, if we didn't say free and democratic society. Now, yes, lower courts have ruled with the governments, but no high courts have ruled on this yet. And unfortunately, those 2 lower courts even forgot their own superior court. The Supreme Court of Canada ruled in 1986 about Section 1. The Oates test is called. And in the Oates test, they made it very clear that the onus was on the government to prove what they were doing was necessary. That's not even mentioned in the Manitoba case that went the government's way, nor in the BC case. That will be taken up, don't you worry, in all of the appeals that are going forward in the Court of Appeal, because the courts themselves never even adhered to their own rules that had been established earlier by the Supreme Court of Canada.
Talking about your case specifically here, as you've noted, there have been 2 years of legal challenges. None of them have made their way up to the Supreme Court yet. There's a huge backlog in courts as people take lockdown fines that they've had and bigger matters like this to court. So this could take years, and in that time, the government could say that we're rescinding the mandate. The government could at this time, using its government powers, take it away. There's a bigger point here, I think, which is that even if it takes 5 years to get to the Supreme Court and the mandate is long gone, the pandemic is declared over, there needs to be something on the record so that this never happens again. You're in it for the long haul, aren't you?
I'm in it for the long haul, no question. I want to see the Charter of Rights and Freedoms, the Constitution Act of 1982, restored in all its simple and plain meaning. That's what I want to see, because like I said earlier, if it's not, then it sets a precedent for another time and makes it far more difficult for our freedoms to be protected and safeguarded. So we're in for the long run. But remember, this action goes to the Federal Court of Canada. It's not in the province. It goes to the Federal Court of Canada, and then either side has the right to appeal, depending on who wins and who loses, to the Supreme Court of Canada. We are asking in our application for an expedited hearing on this, because we think this is extremely important for individuals who are unable to travel right now, and for business who are unable to travel. That's why.
And it's not just you, I should say. There are other applicants here who are being denied the right to see their family, not just to go on some vacation, but to see their family, to do their work. There are a lot of things at play here.
Yes, I'm just characterized because of my former involvement as First Minister in the Constitution. I'm characterized as the lead sort of applicant, but there are other applicants a part of this legal action that we're taking. For the same reasons that you gave, that obviously there are many Canadians who are being affected personally and business-wise as a result of these actions, which have not been justified under the Section 1.
The Honourable Brian Peckford, former Premier of Newfoundland, before it was Newfoundland and Labrador, former Premier of Newfoundland, Brian Peckford. Thank you so much for your time. Good luck with the case, sir.
Thank you very much.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.